You're watching Bill on Bankruptcy. I'm Lee Pacchia. Joining me now, as always, is Bloomberg News bankruptcy columnist Bill Rochelle. Be sure to go and read his daily bankruptcy column, available on BloombergLaw.com, and it's also on the Bloomberg terminal. Bill, welcome.
Good day.
So the bankruptcy court handed down an opinion saying that Detroit is eligible to file Chapter 9 municipal bankruptcy and has the right to reduce retirees' pensions. Bill, was there anything surprising in the opinion or anything that could potentially give Detroit trouble in the future?
Well, I like the way you put the question because the answer is yes on both counts. And by the way, if you have, say, 5 hours and nothing else to do, I recommend reading this 150-page opinion by bankruptcy judge Stephen Rhodes. It is a treatise on what you should do if you want to wreck the finances of a city over a course of several decades. Judge Rhodes, as you can imagine in his opinion, found that the city of Detroit was insolvent, one of the requirements for bankruptcy, and he also found that the city met numerous other requirements for being in Chapter 9 municipal bankruptcy. Where it was less than perfect for Detroit was on the question of whether the city had engaged in good faith negotiations with the unions and retirees before bankruptcy. And on that count, he said no. The negotiations did not meet the good faith standard. The city, as a result, can expect to be facing in the future some rather colorful pleadings by the unions and retirees who will wave this opinion around to say that, well, in substance, bankruptcy judge Rhodes found that their pre-bankruptcy conduct was in bad faith. Mm-hmm. Now, if you've been around bankruptcy very long, you know that bad faith is a real no-no. Of course, Judge Rhodes had a fallback. He said that, well, nonetheless, the bankruptcy code says you can be in Chapter 9 municipal bankruptcy if negotiations are impracticable. And that's exactly what he said, that there was no way on God's earth that Detroit could have wrestled together all of these cats and gotten them to agree on something before bankruptcy. Still, at the same time, he said that the city did not give the labor unions, etc., enough information before bankruptcy from which they could even have mounted a counter proposal. So I'm kind of thinking that when time comes for an appeal, and that's really kind of unclear right now, that the language in the pleadings by those who oppose the municipal bankruptcy are going to be rather colorful. And by the way, in terms of the appeal, it's not entirely clear that the unions and the retirees have a right to appeal right now because it's not a God-given clarity here that this finding of meeting the standards for Chapter 9 is an appealable order. Also, of course, where the appeal goes is up for grabs to be decided, I suppose, on the 16th of December by the bankruptcy judge, because the unions wanted to go directly to the Court of Appeals. The city, I suspect, is probably not going to want to have an appeal at all. In the real world out there, Lee, the best way to get this case over with as soon as possible is not to muck around much with appeals. Let the city file its plan in early January, and then let everybody face a confirmation hearing as soon as possible. When everybody is looking down the barrel of a gun, in bankruptcy, that's when you get things done. If appeals are allowed, this thing is going to be hung up for another 6 to 9 months to a year just on appeals, and the city will come no closer to getting out of bankruptcy.
Huge case. Bill, thanks for that. While we didn't have any large bankruptcy cases last week, we did have a notable filing in New Orleans. Could you tell us about it?
Yeah. You know, I remember when I was a little kid growing up in Texas, my parents, with some frequency, would go to New Orleans, which, if you lived in Texas at the time, New Orleans was a place to go to get good food. And one of the places they always came back raving about was none other than Brennan's, a restaurant that has been on Royale Street in New Orleans for about 70 years. Guess what, Lee? It's in Chapter 7, liquidating bankruptcy. Not Chapter 11, but a liquidating
That's a big
Chapter
name. What
7.
happened?
Well, you know, nothing lasts forever, as my old grandmother used to say, and I guess that's what happened to them. Brennan's, by the way, was the restaurant that supposedly invented the bananas Foster. Ergo, folks, I suppose, depending upon who owns the things, the name Brennan's and or the restaurant itself may be up for sale by a bankruptcy trustee down in New Orleans.
Can't imagine that stays for sale for long, given how scorchingly hot the restaurant scene in New Orleans has been in the last couple of years.
That's right.
That's a big name. Moving on, let's talk about Judge Jed Rakoff. He handed down another decision in the Madoff liquidation, and as seems to be his habit almost, he did once again rule against the trustee and limit how much the trustee can sue to recover from those who are in cahoots with Madoff. Bill, what did you take away from this episode?
Well, as usual, as you said, Lee, the Madoff trustee, Irving Picard, got his ears pinned back. However, Judge Rakoff did leave the door open for the possibility of being able to get into the pockets of managers of feeder funds who took money from their customers and then in turn invested it with Madoff. First off, Judge Rakoff said that on behalf of the Madoff firm itself, the so-called in peri delicto defense bars the trustee Picard from suing feeder fund managers. In peri delicto is an old rule coming out of the equity courts in England centuries ago, saying that if someone is involved in fraud, that person cannot sue somebody else involved in the same fraud. You got to have clean hands to be able to sue for fraud. And oddly enough, according to Rakoff and most other judges in this country, a bankruptcy trustee steps into the dirty shoes of a company that committed fraud. And so therefore you have to view the Madoff trustee the same as Bernie Madoff himself. The trustee thus has unclean hands and cannot sue based on claims that the firm owns. Judge Rakoff, at that point, went on to the second notion, which is that trustee Picard is suing based on claims transferred to him by the Madoff firm's customers. In other words, the trustee is suing claims belonging to the customers. On that score, the result could be different. Judge Rakoff said that the SLUSA law limiting class actions of all manner in federal courts and elsewhere kicks into play. The key issue there is whether or not there were transactions in securities involved. If there were transactions in securities, then guess what? Trustee Picard is out in the cold again. He can't even sue based on the claims of the individual customers. Here is the issue. The Supreme Court in the first week of October heard argument in a case coming out of the R. Allen Stanford bankruptcy. In that case, the question is, if there were only fictional securities purchases, in other words, in a Ponzi scheme where he never bought anything at all, are the fictional securities nonetheless compliant with SLUSA so that lawsuits are barred? The Supreme Court, I suppose, in another month or two is going to tell us whether or not you have to have actual purchases of securities. And by the way, if you follow what Justice Scalia said during oral argument back in October, you got to have real purchases of securities. So if the Supreme Court says that purchasing securities for real is a requirement, then guess what? The Madoff trustee is back in business. And this is not unimportant either for all of these Madoff customers. So far, the trustee has recovered about, I'd say, 55% of how much customers invested. If he's able to sue for much larger amounts, then there is a possibility, at least a possibility, that customers will be paid in full for how much they invested with Madoff. And by the way, the total is about $17 billion of customer losses of principal. A lot of money.
Let's close out with a trip to the stats section. We now have numbers about bankruptcies filed in November. Bill, are you going to stick with your previous prediction that filings were bottoming out and might rise in future months, or have things changed?
You know, I wish you hadn't asked the question that way because I'm a little unsettled. You know, I have been thinking that things were bottomed out. I'm not entirely clear, but for the time being at least, I'm going to stick with that prediction because, by the way, November had the fewest bankruptcies of all types since the year 2007. In other words, just about the time we were having the big bust headed for the Great Recession. Interestingly, not only were bankruptcies by individuals the fewest since 2007, they were also the fewest commercial bankruptcies and also the fewest Chapter 11s, thus again explaining why so many Chapter 11 professionals are underemployed these days. So far this year, the filings are about 13% below the level for the same period in the prior year of 2012. The statistics are kind of looking like filings are bouncing up and down 1 month after the other. The October filings were up rather substantially from September, but then November was down compared with October. So we have this continuing pattern of bouncing like a rubber ball. And I suppose that one of two things is going to happen now, Lee. Either they're going to keep bouncing and stay pretty much where they are, or there's a possibility that filings will get even lower, but I kind of think we're still bottomed out.
Time will tell. Bill, thanks for that. That's Bloomberg News bankruptcy columnist Bill Rochelle. If you'd like to learn more about the cases and issues we just ran through, be sure to go check out our offerings on BloombergLaw.com and also on the Bloomberg Terminal. You can see more of our videos on YouTube, and you can follow our updates, of course, on Twitter. I'm Pacchia. Thanks for watching.